In this lecture, we will discuss the right to privacy in terms of private sexual activity, and in particular, that activity occurring within the home. There are several very important cases to discuss here that are noted in your text, and also a couple that I want to talk about that are just sort of tangentially mentioned. So the first case is a case called Bowers versus Hardwick, occurs handed down by the court in 1986. And in this case, a police officer was serving a bench warrant to an individual. He went to the individual's house and noticed that the front door was open. And when a front door is opened, that basically means police officer can gain admission to the home without knocking, without obtaining a warrant. No one has secured the premises, and the place is then not private in that sense. And so the police officer enters the home, and he goes around the home searching for the individual that he needs to serve with the warrant, and he is opening doors to bedrooms, and he opens a door to a bedroom and looks in, and he sees two men engaged in homosexual sex. He arrests both of them, and they are charged with homosexual sodomy. And the outcome is that the Supreme Court holds that homosexuality is not a protected right. It's important to note that in Bowers, the question is framed in terms of a fundamental right to homosexuality, to homosexual conduct. And the court goes through, and Bowers goes through a long discussion of the history of homosexuality and the criminalization of it and its treatment by the state to determine that it does not meet any of the tests for fundamental rights that we have discussed throughout this course. We don't have a long history and tradition of recognizing it as a right. Such a right does not lie at the base of our civil and political institutions. Without recognizing it, a free society still would exist, etc. And so Chief Justice Burger just runs down the whole list of things and goes through a long historical discussion of homosexuality and the law in the United States. So here's a copy of a note to a justice from his law clerk, and they've been discussing whether he should dissent in Bowers, and whether that justice should read in dissent from the bench. And the clerk here says that she thinks that he should, and that the majority's treatment is a disgrace, and it is well worth making clear to everyone that what the case is really about. That's an interesting remark. On 2 points, it's very unusual for an individual to say that other members of the court, and in particular justices, we have a clerk here talking about justices, calling the majority's treatment a disgrace. And then she says it is well worth making clear to everyone what the case is really about, what it is really about. This becomes important for our understanding of the next case, because in the next case, we're presented with an almost identical fact pattern, and with one important difference, which we'll discuss in a moment. And the court frames the question completely differently in the way that this justice, when he dissented from the bench, made clear that the case really, in his mind, was not about a right to homosexual conduct. The case I was talking about is Lawrence versus Texas, and that is handed down by the court in the year 2003. I actually happened to be in the Supreme Court room when this case was handed down, and I heard Justice Kennedy read his majority opinion, and I also heard Justice Scalia read from his entire dissent, and it was very fiery and very tension-filled. What a day to be in the court. I was in Washington, D.C. at the time, studying with Gordon Wood and Larry Kramer at a summer institute hosted by the Supreme Court Historical Society, and we happened to be at a party where we ran into Justice O'Connor, And the justice was very interested in what we were doing, and then she said, well, do you plan to visit the Supreme Court? And we said, yes, we plan to go on Tuesday. And she said, no, 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 you should go on Wednesday. And just sort of looked at us, and we looked at each other, and we decided, well, I think we'll go on Wednesday. And sure enough, they handed down Lawrence that day. So the only difference in the fact pattern between Bowers versus Hardwick and Lawrence versus Texas is in the type of law that was at issue. Now, in Bowers, this case came out of Georgia, and Georgia had criminalized both homosexual and heterosexual sodomy. So the state law in Georgia criminalized both, and in this case, the state was attempting to punish a homosexual, and the way the case was framed, the issue was framed, brought it to the court as a fundamental rights case in terms of a fundamental right to homosexual conduct. In Lawrence, the Texas law only criminalized homosexual sodomy and not heterosexual sodomy. And so it was clear to the court that Texas was attempting really here to punish homosexual conduct. But Kennedy frames the issue so that it doesn't even matter. Justice Kennedy, writing in the majority opinion, says the Bowers majority framed the issue wrong. This case and Bowers were not about a fundamental right to homosexual conduct. It was about a fundamental right to privacy in the home, and that kind of privacy is fundamental enough to ensure that individuals, consenting adults, can engage in any kind of sexual conduct without fear of being punished by the state. So the right here is not homosexual sodomy, and it's not even really sodomy. It's sexual activity occurring between consenting adults in the privacy of a home. That's how he framed it. So the question there is, does a law that criminalizes homosexual activity violate the Fourth Amendment's Equal Protection Clause and a person's fundamental liberty in the Due Process Clause of the 14th Amendment? Let's talk about that Equal Protection Clause concern there. So like I said, the way that Lawrence frames this is to say that because you have singled out homosexuals for punishment and not heterosexuals, that's a violation of the Equal Protection Clause. Kennedy deals with that in an interesting way. He says, we're striking down this law because it is singling out homosexuals for punishment when they're engaged in conduct in the privacy of their own home. But if the law criminalized both heterosexual and homosexual conduct, we would not support it. It would fail constitutional scrutiny, because punishing everyone for conduct that is protected by the Constitution does not alleviate the requirement that a policy or a law meet the burden of equal protection, right? I mean, he's also thinking about this in terms of the person's fundamental liberty in the Due Process Clause of the 14th Amendment, and that liberty is privacy in the home to engage in sexual conduct among consenting adults. The court answers this question. Obviously, I've tipped the gaff already. Yes, the court says 6-3. Yes, the law that criminalizes homosexual activity violates both the Equal Protection Clause and the fundamental liberty of privacy found in the Due Process Clause of the 14th Amendment. He goes on to say that Bowers was not correct when it was decided, and it is not correct today. It ought not remain binding precedent, and the court takes the unusual step of overruling a previous case. Justice Kennedy's decisions are very interesting, I think, because he's very methodical about setting out the issue at the beginning of each opinion that he writes. So he says here, liberty protects the person from unwarranted government intrusions into a dwelling or other private place. In our tradition, the state is not omnipresent in the home, There are other spheres of our lives and existence outside the home where the state should not be a dominant presence. Freedom extends beyond spatial bounds. Liberty presumes an autonomy of self that includes freedom of thought, belief, expression, and certain intimate conduct. The instant case involves liberty of the person both in its spatial and more transcendent dimensions. And then he defines the issue. We granted certiorari to consider three questions. Whether the convictions under the Texas homosexual conduct law, which criminalizes sexual intimacy by same-sex couples but not identical behavior by different-sex couples, violates the guarantee of equal protection. Second, whether petitioners' criminal convictions for adult consensual intimacy in the home violates their vital interests in liberty and privacy in the Due Process Clause, and then whether Bowers v. Hardwick should be overruled. So then he goes on to lay out why it is that the substantive reach of liberty under the Due Process Clause extends to privacy, and in particular to privacy in the home. Now, there are dissents in this case, and Justice Scalia's in particular is important. I want to go back just for a moment and look just at one point in Justice O'Connor's concurrence. So she says that she would base this decision entirely on equal protection grounds, and just answer the question before the court whether this law violates the Equal Protection Clause, and not try to answer the question whether a law that criminalizes all sodomy would violate the Equal Protection Clause. But then she says something very interesting, and this is with respect to the police powers jurisprudence that we've discussed. Now remember, the police powers is the requirement that the state govern generally through laws of general applicability that are neutrally applied unless the state can identify some important exception related to health, safety, welfare, or morals. Well, she has something interesting to say about the justification under the police powers that Texas gave, and it was purely a morals justification. She says, this case raises a different issue than Bowers, whether under the Equal Protection Clause moral disapproval is a legitimate state interest to justify by itself a statute that bans homosexual sodomy but not heterosexual sodomy. It is not. Moral disapproval of this group, like a bare desire to harm the group, is an interest that is insufficient to satisfy rational basis review under the Equal Protection Clause. Indeed, we have never held that moral disapproval without any other asserted state interest is a sufficient rationale under the Equal Protection Clause to justify a law that discriminates among groups of persons. Okay, so morals by itself is not sufficient to justify an exception to the neutrality requirement. And also she says, you'll notice she says she would apply rational basis, but that is not the standard that Kennedy would apply. He says that what we're dealing with here is a fundamental right to privacy, and of course we use preferred freedoms doctrine when applying fundamental preferred freedoms. Justice Scalia questions the basis for overturning precedent, and he says, today's approach to stare decisis invites us to overturn an erroneously decided precedent, including an intensively divisive decision, if 1. Its foundations have been eroded by subsequent decisions, 2. It has been subjected to substantial and continuing criticism, and 3. It has not induced individual or societal reliance that counsels against overturning. The problem, Justice Scalia says, is that Roe itself, which today's majority surely has no disposition to overrule, satisfies these three conditions to at least the same degree as Bowers. I think, however, that he has a point here, certainly, but I think, however, Justice Kennedy, he doesn't respond to this in particular because he's framing the issue very differently. He would say that privacy in the home is something that people want to protect. Furthermore, he doesn't declare that homosexual conduct is a fundamental right. He does not do that. He frames it as privacy in the home. The question is privacy in the home, and says that the privacy interests of individuals in the home are so great that we see Bowers as flying in the face of those privacy concerns. Okay, so that is our discussion of Bowers and Lawrence and privacy in the home. Thanks very much.